Who are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about all of those matters relating to estate planning, trust and estate administration, both from your perspective, perhaps as an individual who is dealing with this process, but also from the standpoint of people like my guest and me who are professionals that help people with their estate plans and with the administration thereof. So I'm very excited today to have Craig Redler as my guest. Craig is an attorney in practicing out of Newport Beach, California, one of the most beautiful places in Southern California. And I'm not going to spend a lot of time on his background because I really want you to hear what Craig has to say. And so first of all, Craig, welcome. Thanks for coming on the show.
I really appreciate you having me. Love talking about this stuff.
Oh, good. So Craig, if you don't mind, let's just start out. Give us a few minutes about your background. How did you? You were mentioning before we went live that you used to do radio, and so I'm curious how you went from that to becoming an attorney, and especially to the area of practice that in which you specialize.
Oh God, it was a really long and, believe it or not extraordinarily straight path. But yeah, I'll try and keep it brief to the best to the extent I can. I started out in law practice as a litigator, believe it or not. So I worked for a defense-oriented law firm in St. Louis, Missouri, which is also where I went to law school. And boy, I would say this: any aspiring attorneys, you should litigate at least a little bit. At the end of the day, even if that's not your passion, it's just a good skill set to have, because everything else we do ultimately, how to avoid litigation, how to put your client in the best position to protect them from litigation, or litigation drives a lot of what I'm doing even to this day, even though I haven't been to a courtroom in a very long time. Mm-hmm. So I'm a litigator. I had a friend from law school who we were having lunch, and he said, "Do you do any estate planning?" And I said, "No, I don't." And he said, "Well, that's too bad. I just joined a financial advisory firm. We were looking to set up a network of estate planning lawyers, and it's a lot of business. Anyway, let's order lunch." I'm like, "Well, wait a minute. How much is a lot of business?" and it turns out it was a lot. So I said, "Well, I'm willing to train up if you're willing to work with me." And because I was good friends with this guy, he said, "All right, well, let's see what you can do." And grabbed another lawyer at the firm I was at, and we started our own business, and we crash coursed on estate planning. We took every course we could. It so happened his father was the probate judge in St. Louis County, so he said, "Hey, you can rely on the legal department there." So it was a lot of business. So he was sending us, 20 to 30 cases a month, which is a lot, and pretty much
huge amount.
Yeah, so we got very good. I just, out of the sheer volume, couldn't help ourselves, I thought. And this was really, it was just the two of us, and we staffed up. We got paralegals, and we did nothing but service the referrals from this one referral source for better part of 2 years. And then the same guy came back and said, they were in about 14 states at the time. They said, we're just not profitable as much as we want to be in the state of Missouri with our financial advising services. So we're probably going to not be doing a lot of business in Missouri moving forward. So we had our primary source, dare I say, our only source of business, kind of pulled out from under us. Mm. So we started, neither of us had done, me and the other lawyer had not done a ton about developing other business sources. So we started doing stuff that probably had no business doing and really didn't want to do. We were doing like divorces and DWIs and things like that, which were not particularly challenging, but we were both very unhappy with it. And he ended up he said, "I just can't stand this anymore." And he ended up going in-house with an insurance company. And I soldiered on for a couple months, and it was just impossible existence doing stuff like that. So I'd seen a classified ad for being general counsel at a trust company.
Mm.
This trust company happened to be on a little island in the South Pacific called Rarotonga in the Cook Islands. So
Oh,
I
uh-huh.
talked to them, and they said, "Come on out." And I actually worked in the Cook Islands for almost 2 years as general counsel at a company called South Pac Trust. Um, South Pac had two offices at the time. They had one in the Cook Islands, had another one over in the Caribbean on a little island called Nevis, and they
Mhm.
wanted to open a third one. And they said, "Would you go open this new office for us?" That new office was in Tauranga, New Zealand. So I moved from Rarotonga, Cook Islands, to Tauranga, New Zealand, um, and opened an office, the third office for South Pac Trust.
Mhm.
Worked there for about a year and a half, and actually was doing a case with another trust company called AmiCorp, where we were co-trustees.
Mhm.
And at AmiCorp, the lawyer I was working with there said, I don't know, when this case was winding up, she said, "I'm about to go on maternity leave." And she said, "My managing director really liked working with you. He said, ask you if you're interested in coming over here." So I talked to them, and it was in Auckland, and I was
Mhm.
interested in getting to a bigger city and interested in it was a much better pay. So I jumped over to AmiCorp in Auckland, New Zealand, which in hindsight, kind of wish I hadn't,
Oh,
because every offshore jurisdiction, they all have a niche, right? You would go to
mhm.
the Bahamas for this, BVI's for that, Caymans for this.
Mhm.
Cook Islands and Nevis, of course, for creditor protection for Americans. So the sort of planning we were doing in New Zealand was completely different. It was for
Oh.
ultra high net worth Latin American families.
Mhm.
So I don't know if you personally recall something, the Panama Papers, is that ringing any bells?
Yeah, it does, but I
It,
couldn't tell you what it was.
it
Yeah.
was a data leak, and it wasn't really a data leak. It was a disgruntled employee at a law firm in Panama called Masick Canseco, if I recall. And this person just handed over all of the firm's records to something called the ICIJ, the International Consortium of International Journalists, who just published it. It's still out there. You can
Wow.
Google ICIJ data leak Panama Papers, and it just showed every structure this firm had set up all over the world. Which just my little, I don't want to waste too much time on this, but just my editorializing on that. There was no allegations anybody was doing anything illegal. It wasn't like this family was not paying taxes or this family is laundering money. It was just like rich people have these things, and we all know how rich people are, right? And really no different than if someone went to any, wherever anybody listening to this is sitting, there's probably a Bank of America within a couple blocks.
Right.
Someone walked into that local Bank of America, ripped a hard drive out of one of the computers, and just published everybody had an account for no particular reason.
Right.
And that's kind of what happened. But anyway, uh, New Zealand was servicing by and large these ultra high net worth Latin American clients,
Mhm.
and they were not, again, you go to the different jurisdictions for different niches, and what they were looking for, it wasn't creditor protection. Lawsuits weren't a problem for these people. What they were looking for was two things. One was privacy.
Mhm.
If you were an ultra high net worth South American family or Mexican family, kidnapping is a big deal down there. So that is honestly a real thing. So they don't want
Yeah,
anybody to know
yeah.
how much money they have, and to the extent that it gets out, they have some money, they want it known. You kidnap me, you're not going to get any,
Right.
because these trustees aren't going to pay. So do you want money, or do you want to kill somebody if you're, go somewhere else if you're looking for money? And the
Right.
other thing they were looking for is tax deferral. So
Mhm.
unlike the United States, where Americans, we get taxed dollar one day one. If I earn a dollar anywhere doing anything, I owe money to the federal government, and I owe money to whatever state I happen to reside in. Most of the rest of the world, it doesn't work that way. If you earn money away from your jurisdiction, you don't pay the jurisdiction you're in. So if you're an ultra high net worth Argentinian, and you've got a company in say Hong Kong, and it's owned by a New Zealand trust and it earns $100,000 this year, you're not going to owe any tax to the government of Argentina unless or until you bring it home.
Mm, mhm.
So now you've got another $100,000 to roll over, and you can see where the compounding would be much better. Where Kevin, if you and I were doing that, doesn't matter if we had a Hong Kong company owned by New Zealand Trust, we earn $100,000. We're going to clip it almost 40%, depending on where we live, to pay
Right.
the federal government and the state government. So that's what they were looking for. Totally different kind of planning. But when the Panama papers broke, so New Zealand, back up a little bit, it is a super clean jurisdiction. By the way, most of these foreign jurisdictions are, and that's contrary to popular belief. Most people see the Jolly Roger when they think offshore, but I'm telling you, a lot of them run very tight, very clean businesses. But New Zealand is one of the tightest and cleanest. If you were to Google right now, the least corrupt countries in the world, New Zealand would be top 2 or 3 on every list.
Wow.
Going back 100 years. So
Interesting.
The South Americans wouldn't use the island jurisdictions because they weren't as clean, and their governments would look at if you were that ultra rich Argentinian I was talking about, and instead of setting up in New Zealand, you went to some place like the Bahamas or the BVI's. Government of Argentina would say, I don't know what you're doing there, but we don't like the jurisdiction, so we're just going to tax you 20% just cause. So they didn't do that with New Zealand. So that's why they use New Zealand. New Zealand didn't have particularly good trust laws. It was just codified common law. Like I go tell you, like in the Cook Islands, their trust statute is really magnificent. Where the New Zealand statute, it's been updated since I left, was kind of average, but that's not why they were using the jurisdiction. The clients that went there were looking for those two things: privacy and just again that it was a clean white label jurisdiction,
right,
and for tax deferral. So anyway, when New Zealand, again, which runs this clean ship, and I'm sorry I've taken too much time on this.
No, not at all. Not at all. This is fascinating.
They when they were lumped in with the Bahamas and PVIs and Caymans of the world, when the Panama Papers broke, they were not extraordinarily happy about that. So they basically legislated away their industry. So the New Zealand trust industry, it was June 2017 or thereabouts when new laws were enacted, literally lost about 75% of its business overnight. And then that was quite intentional. So my company was one of those. And they just, when I started at AmiCorp in Auckland, there were about 25 employees there. When I left, they're down to about 12. And they're still there. I think they're 2 or 3 right now.
Wow.
So they came to me and said, look, you're an American. We just lost all this business. Will you go to one of our American offices? And they transferred me from Auckland to Miami, Florida. So I moved to the AmiCorp office in Miami, Florida. When I hit the ground in Miami, I sent out emails to people I've been working with over the years. Hey, people I've been working with over the years back in the United States, living in Miami. Here's what I'm doing. If you're interested in you get this direction, give me a call. We can go out, get coffee or whatever. And one of the people I reached out to is a lawyer here in Orange County, California. And he called and said, hey, I always liked working with you. He used to send a lot of business to the Cook Islands. I always liked working with you when you were in the Cooks. Are you interested in getting back in private practice? And that's how I found my way out here. So it was a most indirect path.
Yeah.
But, very good experience. As far as I am to this day, the only lawyer in the United States that's ever lived and worked in the Cook Islands in this industry. And why is that important? If you're an American and you were interested in protecting your assets from being lost in litigation, there's no better place to do it than the Cook Islands. And just by way of foundation, if I were to sue you, Kevin, and I were to get a judgment against you, I could get what's called a writ of execution. Unless you whip out your checkbook and pay me right away.
Right.
I can get this order from the court. I can go to wherever it is you bank, wherever it is you have a broker. I can take this writ of execution. Say you just have a cash account at Bank of America or something. Could walk in there with this writ and I can take your money. Really that simple. What the planning I'm doing now is designed to prevent that. It is a ethical and legal way just to make sure that never happens. If we were to take that same money that's sitting in Bank of America that's vulnerable to judgment, and I were to take it and put it in a bank that does not have a presence in the United States, and these are good banks, we're going to go to Switzerland or Germany or somewhere like that, and take that same account, and rather than have it owned in your own name, it's owned by a trust in a good jurisdiction, a top tier protective jurisdiction like the Cook Islands or Nevis. That'll never happen. I can get all the writs of execution I want. So
and just staying on that point for just a moment, here in like California, where I started out life as a law clerk. So one of my jobs was if we were pursuing on behalf of a client, whatever was a civil suit, and if we had a reasonable enough likelihood that we were going to prevail, we also might look to put a writ of attachment on the the assets of the person we're suing, which of course that's a whole nother thing because that ties them up, right? So with respect to a trust in the Cook Islands or Nevis, I would think that again, the writ of attachment would mean nothing because they wouldn't recognize the jurisdiction of in this example, the California courts.
Correct. And under Cook Island law, and it works the same way in Nevis, they are forbidden from recognizing foreign process in any manner. So to the extent you try to a lis pens or something like that, or some kind of writ against property prejudgment, it would be equally ineffective, which is why it's a good time to mention it's important to do this kind of planning prior to any kind of loss or any kind of claim, rather.
Mhm.
You can't do it after. If I sue you today, you can't go set one of these up tomorrow. That's going to be a fraudulent transfer. However, flip the page. You set one up today. You commit a tort, breach of contract, whatever it is you've allegedly done tomorrow. Theoretically, you're okay.
Mhm.
So
So talk to us about some of the mechanics, if you would. I mean, I did a little bit of research about Cook Islands Trust. So I now know enough to be, really dangerous, right? but take us through some of the mechanics, so people can understand how does this work, what is involved.
sure. Okay. So the trust itself, generically, and some legal gobbledygook, it is a discretionary, irrevocable, or an irrevocable, discretionary, not self-settled trust.
Mhm.
All right, so that is the nature of the trust. So that the important two important terms in there is irrevocable and discretionary, and that's going to differ pretty much from most of the trusts most people are going to be familiar with. So most people in the United States are familiar with these revocable living trusts.
Right.
All right,
Mhm.
and that's just a basic estate planning tool that anybody that owns anything ought to really be consider doing if you haven't done that.
Mhm.
It's just probate avoidance, and it saves the family a lot of trouble and a lot of expense when someone dies or someone becomes disabled. So
Right.
these trusts, they do check a couple of those boxes, but that's not really their purpose. But so let's first start with irrevocable versus revocable. Revocable living trusts, as the name suggests, are imminently alterable, revocable, easy to change.
Mhm.
An irrevocable trust, and that scares some people, is theoretically not.
Mhm.
But I would suggest to you that that's just kind of it is not an absolute. An irrevocable trust is far from irrevocable. It just requires additional steps, and this just
Mhm.
depends on how it's drafted. But they're different in that respect. They're harder to change, but
Mhm.
certainly are alterable uh, under almost any circumstances. But different conversation for a different day. So
Mhm.
it's an irrevocable trust, a discretionary trust. So what that means is you have to give the trustee absolute discretion to
Mhm.
do what it wants, which is also scary for most people.
Mhm.
If and by the way, you have to hire a professional trustee in the jurisdiction where we set these up. So if it's a
Right.
Cook Island trust, you're going to need a trustee in the Cook Islands, which also will scare a lot of Americans.
Mhm.
We don't trust people in other countries by and large, and certainly not on a little island in the middle of nowhere that a lot of us have never even heard of, where they're literally in the business of not getting sued. What do I do if this trustee disappears? So
Right.
those are some hurdles, but we'll get to that in a sec. But back to the differences.
Mhm.
So you can never say, trustee, I need money for a new car, give it to me. All
Mhm.
right. You have to say, trustee, I understand I can't force you to do anything, but in your discretion, would you please consider buying me a new car or sending me money because I need a new car?
Mhm.
All right. I will tell you that these trustees understand their role here.
Mhm.
They will very seldom come back without a very good reason and say, "No, we like the car you have. We're not going to buy a new car." Sometimes trustees are asked to do that. I've had multiple, I've been doing this for decades now, and it's certainly not unusual when a family will come in and say, "Look, we have 3 kids, and 2 of them we trust. We have no problem with. The third one, love him to death, but he's just not the brightest bulb in the box, and we don't necessarily trust him with unfettered access to cash. He's going to go out and do something to hurt himself." Um, These trustees, unless we ask them to do that, they understand that's not their role. Their role is to stand between you and your creditors. So they will, by and large, do anything you ask them to do, with two exceptions. And the two exceptions would be if you ask them to do something that is completely and ridiculously beyond any realm of fiduciary duty.
Mhm.
Just thinking of an example, hey, trustee, I need all the money in the trust because I want to finance my own trip to Mars. They're probably not going to do that. Hey, trustee, can I have some money? I want to buy a truck full of cocaine and take my friends to Las Vegas. They're probably not going to do that.
Mhm.
But short of something completely over the line beyond fiduciary duty, anything reasonable, I need money to buy a car, I need money to remodel my kitchen, I need money, whatever it is, I want to invest in a new business. They're not going to tell you no.
Mhm.
On the off chance that they do, there's actually backdoor control, and talk about that if you like to. But if I can put anybody's mind at ease and assure them that they're not going to be shut out of their own money, even though if you read just the document straight away, it may at first glance read that way. The other thing they're not going to do, and this is where it's important,
Mhm.
is they're not going to do anything that you are asked to do under duress. So, hey, trustee, I need some money so I can pay this judgment that just got entered against me. Well, they're going to take that as immediately you're under duress. The court is making you do that.
Mhm.
Nobody wants to pay a judgment. They're only going to do it because somebody's trying to make them. That's duress. It's the definition.
Mhm.
So they're not going to do that. So those are the two times they're going to tell you no.
Mhm.
But
Now,
that's a little unsettling, just having to call and ask
yeah.
permission to use your own money.
Now, with respect to the discretion that the trustee has, um, how much direction, if you will, to which the trustee would have to adhere can be put in the trust document itself?
You can put as much as you want. Okay, it is you can 100% micromanage just like you will with a revocable living trust, which a lot of people do.
Mhm.
Dear, trustee, I'm the trustee while I'm alive and healthy, and the second I can't do it, my successor trustee, you are instructed to do A, B, C, D, and it's
Mhm.
usually something like award everything to my surviving spouse. If my spouse doesn't survive me, separate shares for my kids,
Right.
whatever it is, you can put all that in. I would advise anyone don't do that.
Oh,
The way because the problem is if a trustee has no discretion and you say, all right, when I die when my kid hits the age of 25, give him $1 million or give him the balance of the trust or give him an income of $100,000 a year, whatever it is.
mhm.
Now his or her creditors can intercept that. The trustee has no choice
Mm.
at that point.
Right.
So
Right.
what I would always do, the way we let the trustee know what it is we want to do, is we send them precatory letters of wishes. And the letter, that's what it's called, letter of wish, and call it any number of things, but it's a letter outside of the trust itself that says what I mentioned earlier. Dear trustee, I know I can't force you to do this, but it sure would be swell if you'd consider doing the following.
Mm.
And I will tell you that they will almost always do it, except for those couple of exceptions.
Mhm.
So if you say it would be my wish that you give my adult children $100,000 a year income, you don't even have to specify, unless they're under duress.
Mhm.
Um, it's kind of built into the sauce, and presumably the beneficiary will let them know too. Well, look, this year, why don't you just hold my 100,000? Because if you give it to me, this creditor is going to take it, or I'm going to lose it in this divorce proceeding I'm in the middle of with my
Mhm.
my spouse. There are any number of reasons. Maybe you don't want the distribution,
Mhm.
or the better plan, in my opinion, is leave it alone. These trusts are, when we set them up, pretty typical for a family, and it's mom and dad will come in and say we want to do this, and we set it up, and initially the beneficiaries, unlike with a revocable living trust where the beneficiaries are typically going to be the settlors, we make it everybody in the family. So it's mom, dad, the two or three kids, whoever it is.
Mhm.
And again, the trustee just knows that while the settlors, the people that created the trust, are alive, they're ultimately going to be giving direction, and don't necessarily take direction from an 18-year-old kid. They're not gonna.
Mhm.
But what happens there? So we've got, say, two kids, mom and dad. So there's got four beneficiaries when we settle the trust. I sign it, put some money in my bank account, and now I've got four beneficiaries. Dad dies. Dad's typically the first one to go.
Mhm.
Dad dies. It's a non-event as far as the trust is concerned. The trust
Mhm.
just keeps plugging along, and instead of 4 beneficiaries, now it's got 3.
Mhm.
And we usually write them to where it's the beneficiaries are initially the family, and then uh, the heirs down the line.
Mhm.
So sometimes you hear the term dynasty trust.
Mhm.
So these things, if there's enough money in them, they literally can go on for generations if that's how you want it to be. Now you can specify. I'm not worried about my kids' liability.
Mhm.
When the settlers die, distribute, and here's who you distribute to, and here's how you distribute. Or sometimes the kids come along and go, "Yeah, Dad was in kind of a business where he manufactured something, and was always worried about products liability. Well, I'm not in that business. I just work as a middle manager at this publicly traded company. I don't have a lot of personal liability, so I don't need the trust anymore. Can you just distribute it all out to me?" And the trustee would do that under those circumstances. So the answer to your question is you absolutely can do it. I
Mhm.
just typically, unless there's a very good reason, don't.
I mean, it is interesting because in that respect, typically here in the States, when somebody creates a trust, they're creating it with the broadest amount of discretion for the trustees because that really allows the trust to be as effective, even in an estate planning, situation where protection from creditors isn't particularly the issue. Trustees are given a broad discretion, and that typically works out the best for the people involved.
Yeah, and that's exactly right. But the difference there is when I set up the revocable living trust, I'm going to make myself the trustee. So I
Right.
want to give myself so it's still a different mindset. But you're 100% right. That's a
But
great way to look
even the
at it.
successor trustees end up having that discretion, right? So then once the
Sometimes.
settlers
Mm.
pass away, and now the trust is irrevocable, and there's some sort of successor trustee has stepped in. Typically, they're keeping pretty broad discretion as well.
I would agree with that.
So you mentioned that these, Cook Islands Trust or Nevis, it'll have to be a local trustee. I assume it's a trust company typically,
Usually, yeah,
right?
or a
So
lawyer or someone. Mhm.
right, or a lawyer. So talk, if you would, about um, the amount of assets one would need to have in order for this to be an economically efficient means of asset protection, and what are kind of the scope of the administrative costs necessary to maintain the trust.
Great question. And the answer is this: it depends on who you are and what you do, and believe it or not, who your lawyer is. Honestly, uh, the obviously you need some assets that are worth protecting before you're going to bother with this. So typically, the people that do it are high net worth,
Mhm.
um, but not exclusively. It depends again on what you do. So picture two clients, two typical. Let's stick with high net worth, but not ultra high net worth. Comfortable people that are very comfortable. Say it's two clients that both have a balance sheet that has, say, at the bottom line, $10 million. Just keep it an easy figure to remember.
Okay.
So that's a pretty comfortable person, but not someone with 100 million.
Right.
Um, and say client one is a CEO or a CFO at a publicly traded company. So
Mhm.
that person makes pretty good money. He's got a good salary, uh, incentives and bonuses and things like that, and
Mhm.
retirement plans. And they've managed to put away $10 million. That person still does not have a ton of professional exposure. Publicly traded companies get sued, and they get sued a lot, but the executives are not going to be named. I mean, literally, if you Google or Amazon or General Motors or Ford, probably going to get sued somewhere on the planet multiple times a day, and that's probably not an exaggeration.
Right.
But you're usually not going to name the executives, and to the extent you name one of them personally, company's going to indemnify them. So there's
You have
normal.
insurance.
Yeah, exactly. But there's normal losses they have to worry about.
Right.
But a lot of this planning, it's not for car accidents. Look, you have auto insurance for that. And
Right.
yeah, it is possible to do exceed the value of your auto insurance. It doesn't happen a lot, but maybe you consider it for that rare situation. And you own a vacation home, or someone hurts themselves on it, or rental property or something like that. So that, they may still want to do this, but they're not going to be as motivated. Let's contrast them with client B here. Same $10 million bottom line, but this person isn't an executive at a publicly traded company. He or she owns a chain of restaurants or a manufacturing facility, has employees. I always bring that up. If you've got 50 employees that work for you, and in my world, that's 50 potential plaintiffs. I mentioned earlier, you manufacture something. Every widget you put on a store shelf is a potential products liability case.
Right.
You own a chain of restaurants, food poisoning, someone gets hurt on the premises, you've got problems with landlord suppliers. There's any number of risks in running a small business. So that person's going to be a lot more motivated, I think, to do the kind of planning than the CEO, CFO. But having said that, I've done work for people that don't have near that much money, but they're in kind of the build out stage, and they're high profile, and it's something that the growth is right in front of them, and they see it coming. So it's planning in advance. So, but typically my typical wheelhouse client is going to be that small business owner. That client B I talked about just a minute ago. And then we do athletes and entertainers and other high profile. You're an athlete, you're 23 years old, everybody knows you've got millions. You go to a bar and, hey, you think you're tough, they want to, or you tap them at a red light, you get out of your Bentley and they're like, oh, this guy plays for the Lakers, I'm gonna nail him.
Right.
So
and take that business owner, then is his business put into the Cook Islands Trust to protect it?
It depends on how the business is structured. So that's another thing. We do the acronym I use is a FAPT, is a Foreign Asset Protection Trust. So we do something called an EFAPT, which is an entity FAPT. So we can do the planning for the business, also the business itself.
Okay.
And by the way, for asset protection planning, just to be clear, it's not 100% foreign trust. That's just one tool in a fairly broad toolbox these days. It is the best gold standard kind of planning for liquid assets. You really can't do any better. But there are other assets that just are inappropriate for a FAPT. But to your question, yeah, look, if the shares of a small business have value and it's something that would be of value to somebody who's trying to sue you, then absolutely we can run the business through the FAPT. Flip side of that is the business itself is out conducting business and client facing, which most of them are. We can put its assets in an EFAPT, like I mentioned, if businesses that hold cash, or if you've got a business that's got a fleet of trucks or anything else that is of value that a potential creditor can come and try and take from the business, we want to put the same umbrella of protection around them. And it may not be through a FAPT or an EFAPT. There are other things we do. So the answer is, yeah, you'd want to you typically would consider putting shares of a closely held business in one of these, or the business assets itself.
And when you have the trust set up, presumably it's doing all of its banking, et cetera, in the Cook Islands, to use that example. The beneficiaries, though, probably still have just regular bank accounts here in the United States. So there's some sort of methodology for moving funds back and forth. Is that pretty much how it works?
Yeah, and to clarify, the bank can be anywhere. All right, the trust doesn't hold the money itself. It's got to use it. It's going to use a bank. So while there's actually only one very good private bank in the Cook Islands itself, and I use them all the time. But it's not, when I say all the time, I mean probably still less than half. Most of my clients are going to use banks in Europe somewhere. Used to use Asia a lot, but the Asian banks are getting really hard to get into. But the banks in Hong Kong and Singapore and Switzerland and Liechtenstein are terrific. I mean, they're AA rated banks, or AAA rated banks, or they're as good, if not better, than any banks here in the United States. So we would typically use a European bank more often than not. But the answer to the question again, still, if you're using Pictet and C Bank, we're not. They don't have ATMs on the corner.
Right.
what you would do is just a wire transfer. So you open your trust. We open a bank at say Kaiser Partners or Pictet or somewhere in Switzerland. You got a bank account here at Wells Fargo or Bank of America or Chase or one of those. Literally just wire money from Chase to Pictet,
Mhm.
and now your trust is funded. It's an account owned by the trust. And that's where your money is. And again, it's difficult to spend that money. If you need it for something, you would do one of these letters of wishes I talked about.
Mhm.
Dear trustee, I know I can't force you, but it sure would be swell if you'd consider sending money to my account here in the USA because I need a new car.
Mhm.
All right. And here are the coordinates to my bank, and the trustee will order the Swiss bank to wire money from that account to your account here in the States where you have direct access to it. Or you can actually have money wired directly to whoever it is you need to go to. So in my example, maybe they wire money directly to the car dealer.
Got it. Uh-huh.
So or whatever it is, to the escrow company if you're buying a house or something. So if it never passes through your fingers. And so if there's an open judgment out there, it can't be intercepted. It can't be grabbed.
Right. So for day to day, living expenses and such, typically it sounds like that wouldn't be funded by the trust. That really the trust is there to protect assets as needed to deal with perhaps larger expenses that someone might have, but to buy food
Yeah.
and
Yeah.
whatever you're gonna that's gonna happen in whatever your regular source of income is.
It is. That's exactly right. It's your savings is typically what it is. Now we have some clients that are in the wind down phase of their careers,
Mhm.
where they're not really working anymore and use this money to live off of. And what we would typically do there is we would tell the trustee, just pay a monthly allowance, a stipend, whatever you want to call it,
Okay.
just every month, just routinely, unless I tell you otherwise. Plan on the first day of every month, wire me $20,000, and you just do it that way. I would tell anybody to keep their personal accounts here just funded to the extent they need it. I mentioned earlier, go to the ATM and go buy dinner or
Mhm.
pay their bills or whatever. And yeah, you want to leave the bulk of your savings overseas if that's how we have it set up.
And how does the tax situation work? Presumably, the assets that are being held by the Cook Island Trust, they may be appreciating, they may be
Mhm.
generating income. So, how does that work with respect to both, taxation in the Cook Islands, taxation here in the United States, and then
Cook Islands. Oh, go ahead.
sorry,
I'm sorry.
and then just to add on to this, what happens when, let's say, the trust, let's say I have a Cook Islands trust, and I say, hey, trustee, if it's okay with you, I'd like to have $20,000. Okay, so they send me $20,000. What happens tax wise with money that's sent to me?
Got it. Okay. The Cook Island Trust is tax neutral. It's 100% by design. It doesn't have to be, and there's sometimes we don't want it to be, and a different story on a different day.
Mhm.
But they are uh, self-settled grantor trusts. All right, and that basically makes them disregarded as far as the IRS is concerned.
Okay.
So any income it generates. So that, by the way, in this planning, and just to be clear, you can do tax planning, but there's nothing magic about offshore. So a lot of people think that you go offshore, it's obviously a tax scam. It's absolutely not. There is a statutory regime out there called FATCA, the Foreign Account Tax Compliance Act, which makes that impossible. But that aside, most of the trustees weren't playing that game anyway, and really haven't been for some time. I'm not going to insult anybody's intelligence and say 40 years ago in the 80s they weren't doing that sort of stuff, but been a while. So,
Okay.
that's not the game they're playing. It is everything is transparent to the IRS, everything is reported, everything is tax neutral. So if you have an account here in the USA and it's invested, and say it earns you $100,000 in interest or dividends or whatever it is, just like the domestic bank's gonna send you a 1099, the foreign banks do basically the same thing under this FATCA regime. So
Okay.
the IRS is going to know about the income. It's going to be, to the extent there's a tax due and owing America, we get taxed $1 day one the minute we earn it.
Mhm.
it's reported. You better report it on your 1040 because the IRS is going to know about it, and you got to pay your taxes on it, just like anywhere. And by the way, the trustees do take fairly extreme steps to make sure you're tax compliant. They do not want to help anybody evade taxes. That's not what they're about. It, and then distribution, by the way, it does not trigger any additional tax. It's after tax money, presumably.
Okay.
So the flip side of that coin is if you have to liquidate a security, for instance, to generate cash to do something, and there's a capital gain, to the extent there's a taxable consequence to doing that, it has to be paid, just like if you're doing it domestically.
Okay. And what if someone's wealth is primarily in real estate? So let's just say they've got 5 properties, to use your numbers to make it easy. They're worth $2 million a piece, right? They're generating income. The expenses have to be paid, so there's a property management company that's handling that. Again, is that going to work essentially like it would both operationally and tax wise, as if it were owned domestically, as opposed to the Cook Islands Trust?
Yes, it will work operationally and with regard to taxes, exactly the same. But there's got to expand on that, and that's a great question. We live in California. I do business all over the country and all over the world. And for real property, a trust like this does not do you a ton of good in a state like California. And let me explain.
Okay.
These irrevocable discretionary spendthrift trusts that I've been talking about in 21 American states are recognized as asset protection vehicles, which means in 29 states they are not, California being one of them. All right. So the way it works, if you're in one of these states that recognizes them, and say, for instance, the one that's closest to us and the one that's probably as well known as anywhere is Nevada. Okay. If you have a Nevada trust and you have Nevada property in your Nevada trust, and you get sued by someone in Nevada or someone who's another Nevadan, the argument technically is, if I go to sue you and I get a judgment and I try to execute my judgment against your property, you would go to the court and say, court should not be allowed to execute against that parcel of property because it's not mine. It belongs to someone else. And the court will naturally ask, well, all right, who does it belong to? And the answer is, it belongs to the XYZ trust, or whatever your trust is called. Nevada will look at that and go, oh, so it does. Motion quashed. California will look at it and say, yeah, good try. We don't recognize, if it's a self-settled trust, if you set up a trust, even if it's one of these irrevocable spendthrift trusts, and you set it up where you're the beneficiary, California looks at that and says that is not an asset protection vehicle. So that's fine. Look, with cash, you can pick up cash, you move it overseas. It doesn't matter what California says. When you talk about real property, you can't pick up your real property and move it overseas. It's always sitting a couple blocks from a California courthouse somewhere. And that judge has absolute authority to do what he or she believes what is appropriate with it. And if that means allowing someone to foreclose or put a lien on it or whatever it is, then they do. So the straight up FAPT, Foreign Asset Protection Trust, it doesn't do a ton to protect a real estate portfolio. So in states like California and states like Nevada or Wyoming or Alaska or Delaware or Missouri or Tennessee or Ohio, I can go on the 21 of them.
Right.
It would work out real nice. So for real property, we have other techniques we use. Now, I mentioned that the trust that I've been talking about is the self-settled trust. One technique that we use a lot is a non-self-settled trust. So a non-self-settled trust is considered a completed gift. All right, and that's an important distinction. So the reason we don't just do non-self-settled trust for everybody is there's some tax consequences and other things that are a little more complicated that you can work around. But if it's a completed gift trust, and so you make your kids the beneficiary, you're not a beneficiary now, and I put it in one of these non-self-settled trusts, the real estate, now that argument's going to work. It's not mine anymore. Well, whose is it? It belongs to the XYZ trust. So there's actually would be a follow-up question in California. Judge would say, well, all right, who settled the XYZ trust? I
Mhm.
did. All right, that's a strike against you. Who's the beneficiary of the XYZ trust? Someone who, not me. You're going to win that argument in California now.
Right.
And then there are other things we can do to protect real estate in California. That's some reallocation of debt and things like that. So there's a couple things we do that'll work. Will protect the real estate portfolio, but it's harder in a state like California than in one of these DAP states.
Right.
So in Nevada, because they recognize that whole concept,
Mhm.
self-settled discretionary spendthrift trust as an asset protection vehicle. Even if you put your property in a Cook Island trust or a Nevada trust for that matter, it will protect it in a state like Nevada, just
Mhm.
not California's and California's of the world and the other states that fall on that side of the fence.
Right. What about if the real estate has been securitized, either maybe it's a limited partnership interest that the person has, or it's some sort of REIT or something like that. Um, would an asset like that be afforded protection by a Cook Island trust?
Yeah, look, if it's a REIT for sure,
Mhm.
you're talking about your interests.
Right.
That's what you own. You own your interests.
Mhm.
You really don't have a whole lot of management over the property itself.
Right.
So you absolutely or a Delaware statutory trust, another tool that people use.
Mhm.
The real estate itself is going to be safe, and if your interest in that Delaware statutory trust or REIT is being held by the trustee overseas, you're golden. I mean that's your firewall.
Okay.
Um, if it's just in an LLC or a limited partnership or something like that, well, to the extent that the entity itself will hold up, yeah. The problem with those are the interests themselves are potentially exposed as assets that a
Right.
creditor can take. But again, if you take the interest, so I've got an LLC that owns real property. I take the LLC interest and I assign it to my trust.
Mhm.
Theoretically, that should work unless or until a court looks at it and says, well, I'm going to allow this creditor to end run the LLC. It's piercing the corporate veils and
Right.
undercapitalization, alter ego. There's a couple strategy or a couple theories that you
Mhm.
can pierce the corporate veil. If you can convince the court that the entity is separate enough from you, then it may hold up.
Right.
Um, the other problem is with the LLC itself is the one that committed the act that got sued. If it committed the tort or breached the contract or whatever it was, it got sued. So you're doing business as an LLC, and your LLC is your operating company, and it owns the building that you operate out of, and it gets sued. Well, its assets are going to be exposed. Which, by the way, is another asset protection technique. Is you want to
Separate it.
separate property of value from the operating company. So in that scenario, get another LLC to own the real property and lease it back to the operating company.
Right.
Operating company is the one that's going out and has a potential of getting in trouble,
Mhm.
and it's only a tenant.
Right.
It's so if the operating company gets sued, the property's still going to be safe.
Right. Right. Absolutely. Absolutely. Well, the hours zoomed by, so we could easily go on for another 2 or 3 hours. I think there is so much here. So, hopefully you will come back again, and we'll delve into some more, because it's fascinating. There's a nexus here, not just between estate planning, but also with like you said, the asset protection, but also how you put all this together for someone who has their own business. All of these things really, they're part and parcel of an overall financial plan that I think people really need to consider. So
I would agree. And if I could say one more thing to that
please.
point, if you have any property and anybody in your life you care about, you should do at least a revocable living trust. All
Mhm.
right. That is just spare the family the agony and delay and expense of probate. If a lot of things like attorneys that do a lot of these revocable living trusts don't talk about this very much. But another scenario where the revocable living trust is just vital is, God forbid, you become disabled. I don't
Mhm.
talk about that a lot. What happens after I die? What happens after I die? Well, okay, that's easy. When someone dies, it's very simple. You've got point A, they die. Point B is distribute all the property, and that line from point A to point B can get a little jagged, but there's an end. There's always the end goal.
Right.
It's infinitely worse when someone gets disabled, and it's certainly rare. We're all going to die, and knock wood, most of us don't spend a ton of time disabled.
Mhm.
But if you've got you own property and you get sick to a point where you can't sign your name or you can't make a decision,
Mhm.
what happens to that property when you're in the hospital and in a coma or something, heavens
Mhm.
forbid. And it's a nightmare scenario. And again, I don't want to could spend hours talking about that
Yeah.
too. So everybody needs to at least do that kind of planning.
Right.
But as a subset of that kind of planning, this asset protection vehicle, it's going to be a narrower group that's going to need it, or it's going to need it. But I wish more lawyers would talk about it and have this conversation. In addition to what happens after you die if you become disabled,
Right.
well, are you in good shape to where if you get sued financially you can survive that? Would you be able to retire on time? Would you be able to eat? I mean,
Right.
how bad can a lawsuit hurt you? Well, the answer to that question is pretty bad.
Right. Right.
Um,
Or get your health care. I mean, I've seen situations where there wasn't proper estate planning done, and the the parent in this case became disabled, and the kids started fighting over the money.
yeah,
Right. In the meanwhile, the mother needed health care. So, you
yeah,
know,
no, 1,000%. And those are unfortunately uniquely American problems, but
yeah.
that's where we all live. So
Yeah, yeah, indeed, indeed. Well, Craig, thank you so much for coming on the show today. I will put your contact information in the show notes after the show posts, so that if someone listening to this wants to consult with you, they'll be able to get in touch with you. I'll put
by all
your
means,
email
that'd be great.
address in there, and your LinkedIn profile,
Perfect.
and what I can tell you is, and those of you who watch the show regularly, I speak to a lot of attorneys. I have never met a lawyer who knows so much about this area, can speak about it, not just so well, but so understandably. Right? Because it's really easy to blow a lot of lawyer lingo and sound intelligent. It's another thing to really understand the inner workings of it. And as you can see, Craig clearly does, and he's got the chops of living in, all over the world, basically, to support that. So Craig, I'm going to have you hold tight for just 1 minute so I can wrap things up and we can talk offline for a
That'd
moment.
be great. I really
So
appreciate you having me. It was a lot of fun. Thank you.
yeah, my pleasure. My pleasure. So tomorrow at 10 a.m. is my 10 a.m. Pacific time is my show, Business Lessons from the Military. We're going to be talking about the Battle of New Orleans. This was really the final battle of the War of 1812, although the war actually was already over by the time this battle was fought. There are some unique lessons that I think we can draw from how General Andrew Jackson and his kind of partner in crime. I use that somewhat facetiously. The pirate Jean Lafitte used in order to win that battle. So I hope you'll join me again tomorrow at 10 a.m. And then Wednesday at 10 a.m. Pacific time is my show, People Making Money. And we're going to be talking about one of the most well-known figures in the self-help world, Dale Carnegie. And I think it's reasonable to say that when it comes to what we now call emotional intelligence, Dale Carnegie really was dealing with the roots of that. And so we're going to take a look a little bit about just his background and who he was, and then talk about his philosophy. If you have never dealt with Dale Carnegie's philosophy, I encourage you to tune in. You will not find a better source for improving the skills that matter most in business, the business and professional world today. And then, of course, a week from today, we'll be back for the next edition of Trusts and Estates Weekly. And my guest is going to be Michael Siegel. And so I invite you to come and hear what Michael has to talk about. So last time, Craig, thank you so much again for joining me. And signing off as I always do, Marie, darling, you are my bell. You know you are. Courage